Hi there, welcome to today's video. Today's video is actually a question submitted by a reader. This is it's probably an issue for those of you that are older and retired and maybe enjoying yourselves and traveling a lot, but it could apply as well in other types of situations that we're going to go over. So let me show you here what the issue is. The debtor, my client. I want to say client. They didn't hire me. This is more of an email thing that you guys could always reach out to me. They're retired and traveling in an RV. My dream. So thank you for taking away my dream. I want to be able to do that. I could do the videos from the RV. Wouldn't that be awesome? Different background all the time, different state, everything. But I'm stuck here. So the problem is, why bother paying the mortgage if someone else will do it for you, right? The problem is right here. It's no longer exempt. Now, the issue is homestead exemptions. I'm going to get into that for a second. But if you're basically renting your house out, first there's the issue of, are you including that in your taxes? Because if you're not, then the trustee could have obviously issues with that and fraudulent tax filing. You're going to go to jail for that? No. But that's why I always ask these questions to clients and make sure the tax returns, don't have any other contradictions where one question from a trustee leads to another, and all the trustee is looking for a big settlement and a big payday. It's just easier to tell clients, go amend your tax returns, get it done correctly, and then we'll file for bankruptcy there. Now, in this case, remember, the client is actually the reader. That's a better term. Let me stop saying client. The reader is actually traveling the country, having a good time. But here's the issue. The reader spoke to a bankruptcy attorney who said, well, you claim homestead exemption, so you're all good. All your mail goes there and everything else. Okay, what is homestead exemption for purposes of the county giving you a tax break is not going to be the same as homestead exemptions when it comes to bankruptcy. There are two different things. You can go live with your domestic partner or your parents or whoever and rent out the house, and you're still going to be claiming homestead exemption. It shouldn't happen that way, but it will. The reality is the trustee is going to find out if you're not residing there. And that's besides the fact that the RV is not even going to be property that's exempt from bankruptcy. So whatever equity is going to have to get paid back. But here's the issue. Trustees go back at least 6 months on your bankruptcy filing with your bank statements. They're going to see deposits that were made into there. They're going to say, who is this person consistently depositing, make up a number, $1,000 per month. That's what you're gonna have to say. It's a renter. Trustee's going to look at the tax returns and make sure that's even listed, because this is income that should be taxed. Also, if you're renting it out, then you don't live there. And if you don't live there, guess what? It's not your homestead. It's not a homestead exemption. Are you traveling all the time? That's the best I could do with an arrow. Are you with my cursor? Are you traveling all the time, having a good time? Yes. But it's not your homestead because someone else lives there. It's rented property. And so a lot of times you see people who move in with their partner. Let's say a boyfriend moves in with his girlfriend or vice versa. And they say, my place is too small. Let's go live in yours. I'll rent my place out. And they file for bankruptcy. That place that they owned before, that's too small, is no longer protected in bankruptcy under the homestead exemption. They're going to treat it as a second property, and none of it is going to be exempt. Not even in Florida, that has a 100% exemption when it comes to home. 100% of the equity in that situation is not going to be protected. So you have to be careful in this types of situation where you're claiming homestead exemption. The county will probably never find out, but the trustee will find out. Now, if you're living there, and you're renting it, that's another issue, right? That's not a problem because you're just renting a room. Again, it's taxable income that should be shown there. The expenses should be higher too. It's another person using electricity, water, etc. And whatever that you're renting out a room, $500 come in, that should be listed there. Now, the answer is people say, trustee's never going to know. They're going to know, like they did with one of my clients, when the question is, who's this person that gets mail at your house? There's a person who's listed as residing at your property. And then that's where yeah, I don't know. And then you finally admit what happened was my client's son was trying to get a deduction on car insurance. And what ended up happening was the trustee was able to confirm that my client's the one who gave the deposit on the sports car in cash. So even if they weren't able to prove that, it just opens the door of asking more questions. It's probably going to lead to a 2004 examination, basically your deposition. And it could get even more complicated with that, with an adversary proceeding where the trustee doesn't want to either grant certain debts as non-dischargeable. So even if you're living there and that rent's coming in, chances are that person receives mail there. And then that's how they're going to find out. And if you say, well, they can't because they don't, it's a P.O. box. What about their car? Their car is going to be registered to an address. It's going to be registered to your address. So if you have renters living in your property and you live there, please go over this with your bankruptcy attorney because it could be a huge issue. And likewise, if you're retired and you're enjoying life, that's great. Just understand that the homestead exemption and the bankruptcy exemption are two different things. And so while you might qualify for one, you may not qualify for another. And these are not things you want to go to court and argue. The trustee has basically unlimited resources. They will litigate this because it's to their advantage to do so. So you have to be careful. And again, 6 months is the minimum. Let me do a better arrow here. 6 months is the minimum. They could go back a year. They could go back 2 years. They can go back 6 months. They don't like what you said at the 341 meeting of creditors, set you down for a deposition, the 2004 examination, and then say, you know what, bring me the last couple of years too while we're at it. So be careful if you're renting your home and you're not living there, whether it's something as nice and sweet as retirement or you moved in with your partner, this is going to create problems with your bankruptcy case. All right. As always, any questions, feel free to reach out to me, post them in the comment section below. And paralegal students, I'll make sure to put that description down below. If you're a paralegal student or legal studies students and you're using my textbook in your courses, or you're a paralegal trying to learn the inside outs of this, I already have posted multiple videos. Probably in the next few days, I'll have the first 11 chapters done. I think I have 7 or 8 posted so far. So go in there. The videos coincide with the chapters in my textbook, and so it'll give you a better understanding of the material. All right. Take care, everyone. Enjoy your retirement. And if you're renting out, be careful.